J'attends que tout le monde... donc nous allons...
So, I suggest that we start with the first roundtable. As I said before, the lawyer as a guarantee of the protection of freedom. I would like to thank Christophe Darbois, the President of ERAGE, and Christina Couguer, which is the President of the Bar of Strasbourg, which helped us to organize all this event during the whole year. So thanks to them. So I have the pleasure to be the moderator of this roundtable. Sorry that the Vice President, Mr. Perakis, could not come today. Unfortunately, he caught the COVID, so it was possible for him to come today to Strasbourg. So he asked me, as an introduction, to say a few words about, in his name and in the name of the European Council of the Bars, European Bars, as far as the guarantees are concerned at the level of at European level, what new European procedural safeguards for the parties to the trial. So he has been interested for about the last 20 years about these procedural safeguards. You know, these European procedural safeguards has always been at the heart of the action of national bars and of the European Council of the Bars. And you know, 6 directives have been adopted in the last 20 years by the Council of the European Bars. And we always, as I said, insert this directives in national laws, the right to interpretation, translation, criminal proceedings, the right to information in criminal proceedings, the right of access to a lawyer of criminal proceedings, and the right to communicate in the case of arrest, new measures to strengthen the presumption of innocence, procedural safeguards for children who are suspects or defendant in the criminal proceedings, and the right to legal aid for suspects and defendants in criminal proceedings. So, of course, this program, which has led to these 6 directives, has taken years, and it is in the framework of recognition between the states, mutual recognition, that these fundamental principle of EU judicial cooperation in criminal matters can be adopted. Of course, it took time to put it into the national law, but what we can say is that these guarantees exist. Sometimes they are not well known by those that practice the law at national level. Sometimes we see that the transposition are not all legal and not of the same legal protection within the member states of the Union. But as far as the CCB is concerned, we have always done our best to transpose the directives in the different member states of the Union. We are conscious that there are still divergence in the way the measures are implemented in the different states, but this doesn't put into question the efficiency of these measures. Then, because these guarantees can enter into force only if they are efficient and applied by national jurisdiction in an efficient way. And is the purpose of the European bars to show the cases in which these directives are not correctly applied, implemented. guarantee exists, but shouldn't we not plan future rights? We believe that these rights are not always complete in criminal law. There are still a scope of action. I speak about the admissibility of evidence. You know, the Lisbon Treaty, in its Article 82A, gives the EU explicit competence to adopt minimum rules on the mutual admissibility of evidence between member states. It's the admissibility of proof, of detention. So Laurent HUET will say a word about this. No directive gives explicits these condition of detention. So members should have provisions which exclude evidence obtained illegally by improper means. The treatment of detention, specifically foreign prisoners, has still to be improved. There is a misuse of European supervision. The supervision order needs to be addressed and improved. European supervision order was to be introduced in the member states by 2012 at the latest, was intended to allow persons accused of offences abroad to await their hearing in their home country under the supervision of local authorities. It's clear that the European supervision order is very little used or not used effectively. So, another field, the defense, investigations. We believe that member states and the lawyers should allow for defense investigation. Investigations carried out by defense lawyers in criminal proceedings in order to gather evidence for their clients, as already provided for in some member states. Other questions are on the agenda. I will take one in particular, the reform of the European arrest warrant. The European Commission has presented 3 reports on the implementation of the framework decision on the EAW. This framework law has shown that it's not up to the challenges. We see, for instance, the multiplication of decisions taken by states about thieves. So this European arrest warrant is difficult to implement. There's a question of mutual trust, so that this European arrest warrant problem could be solved. You can see European arrest warrant poses problems, but to reform this framework decision from 2002 will bring forward more difficulties than offering solutions. The European Public Prosecutor's Office, that's another subject on the table. And the CCBE has been raising defense rights for many years in relation to the European Public Prosecutor's Office, conducted by the European Prosecutor's Office. 4 specific points on this subject: the lack of specific regulation of the rights of defense and procedural rights, the effects on the rights of suspects at national level, the foreseeable problems of access to the file, and the possibility for the permanent chamber of the European Public Prosecutor's Office in Luxembourg to decide in which jurisdiction the investigation or the prosecution will take place against a person suspected to be guilty. So this roadmap on the procedural safeguards should be seen as the beginning of the process that the EU must undertake to strengthen mutual trust between member states in the field of criminal justice. What is essential is to know these instruments. As the chairman of the Paris bar says, it's national law. We have to know how to use them. And the best example of it is the use of this guarantee in the Court for Human Rights. These directives, or the transposition of these directives, exist, and we must know how to use them in order to defend with efficiency the client at the level of national procedure. This is actually, in a few words, what Mr. Beccaris, the Vice President, wanted to say today. I did it for him. I was happy to do it. I'm going to give the floor to Dominique ATTIAS, President of the Federation of the European Bars. Thanks a lot. It is an honor for me and a pleasure for me to have the opportunity to take the floor in this panel at the beginning of the presidency, France presidency of the Council of the European Union. Thanks for the three institutions that have decided to organize the day. Bar of Strasbourg and the RH for here welcoming us here in Strasbourg. So it's a great pleasure, marvelous, to be in Strasbourg, in this city known for the city of Christmas. Thanks for the team of the national French bars. Thanks for all the efforts. I think they will sleep much better tonight after all the works they've done. Thank you, Laurent, for inviting me. It is not said enough, as has said it Jérôme Gavaudan, to the population, members of the European Union. Europe and its institutions are here to protect them and to guarantee their rights. It's a fundamental right. And the right to benefit in justice, to benefit from a fair process, trial. And I say it for my colleagues that follow us with internet, it is the judicial instrument that one of the instances is the directive, which is here to harmonize national legislations and to implement this policy. The directive obliges all member states, Article 288 from the Fundamental Treaty of the European Union, which fix the delay to be so it would be part of national law. Read it again. There are many directives for the right of have a fair trial within the framework of this criminal law. For more than 11 years now, it was in October 2010, the right of interpretation and translation, which has been, I think, transposed 2030. Still a lot of work to be done. The second, which is the right for free legal advice, transposed 2014, a year and a half later. The right to have access to a lawyer. We'll come back to this in the second part. It's from the end, 27th of November 2016. And the one for March 2016 for the reinforcement of the presumption of innocence and the access of the trial. So the right of the most vulnerable people among us should be guaranteed. I speak about the children, and particularly those who are in conflict with the law, which is what we use usually is the non-accompanied minors, but there are other children which are not falling into the framework of these unaccompanied minors. I want to mention as well the directive about the law, the right to have judicial help. Without this help, a lot of children couldn't be assisted. This has been transposed 2019 before the transposition of the directive which we are going to talk about now, because the children, the benefits with the first directives which have mentioned a certain number of rights. Before all, and for a long period of time now, I am a lawyer for children, the lawyer for children, principally, mostly, and I want their rights to be lived. It's one of my fundamental occupation. This is why I speak about Directive 2016/800 from the 11th of May 2016, which had to be transposed 11th of June 2019, concerning the procedural guarantee for children in conflict with law. This directive was to be transposed by France first, with the law 18th of November 2016, modernization of just in the 21st century, so it was called. But more specifically, in March 2019, just before June 2019, this programmation law from 2022 has been prepared in this way for the children through the ordinance from the 11th of September 2019, with the legislative part for the criminal law for children. The code for the minors is something new. Lawyers should use it. It has been actually implemented yesterday. This directive has to be used by you. It brings a lot of benefits. You will see the fundamental role of the lawyer, specialized at the side of the children. Every year, in the European Union, more than 1 million children are followed by the law. There is no domain where more efforts have to be made. The inappropriate answers with children who are in conflict with the law could mark sometimes definitely their future and lead to insecurity. This is not what I said, but Françoise Dickens, which is a judge at the European Court for Human Rights, an introduction of a very useful manual at the initiative of Defense of International Children, ELGIC, destined for member states to allow the implementation of this directive. Please consult this book. This directive, as I mentioned, comes from somewhere. Article 24 of the Charter of the Fundamental Right of the European Union recognizes expressively the fundamental right of the rights of the children and the extreme importance of its right, which has always been mentioned when a child is arrested in the framework of the international European mandate. It's a real problem. No need to remember of the International Conference for the Right of the Children called ACID, which has been ratified by all the member states of the Union which is binding for these European states. Article 37, Article 40 from the ACID, specifically treating the problematic of children. Other sources are helpful. They irrigate the directive. General observation of the Committee for the Help for Children, which is supervising this work. It's very important. Observation number 10, but as well the rule number 5 for the justice for minors. I cited, I quoted. It's looking for the well-being of the minor to make sure that juvenile delinquent should always be proportioned to the proper circumstances of the delinquent. The rules of Riyadh and Havana go in the same directions, like ACID saying that incarceration of a child should be measured at the last possible measure. I'll come back to that later. Thanks a lot. Look at the principle of the Council of thanks to the Council of Europe, the Council of Ministers, a justice adapted for children. We don't know, we lawyers, we don't know enough all these texts. The directive is occupying us, makes a reference in point 7, the present directive promotes the right of the children, taking into account the text of the Council of Ministers for a justice proper for children. What are these new guarantees? Procedure, European procedure, procedural guarantees. 2 observations. One about the definition of the child in conflict with the law. The point 10, which I mentioned just before, says that a children in conflict with law is a human being under 18, except if he can be convinced that he has done some criminal offenses. They want to try to have the majority at 16, which is not a reasonable attitude to adopt. Considering point 66 reminds us of the minimum rules. To find, taking into account the national disparities, to find a consensus, if in the member states are encouraged to offer the children a higher level of protection. This is why it's a minimalist attitude with a lot of possibility to derogate to the law in the framework of this law. The children are the first to suffer from this misunderstanding. Many countries, I speak now about France, many countries as France have made efforts to actually go backward about non-accompanied minors. Look, but we should do, the glass should be half full instead of half empty. Right of information, Article 4 of the directive mentions it. The member state should make sure that the children that are suspected should quickly be informed in a written form or verbally about their procedural rights, about the general aspects of the different aspects of the procedures and the role of the implied authorities in a very simple language and understandable for all of them. Take into account their age, and this on the basis of the directive relative to the right of information. Right to be information, to keep silent, to not auto-incriminate yourself, Article 29, have an interpreter, and as I said, legal free of charge support. and be accompanied by a lawyer. As I said, it's because one of the problems is that in the text, national text, it's not always said. It's simply, there is a link to the original text. So you should not forget to check when they take the defense of these non-accompanied minors. In a very strange way, in the directive, there is a special privileged action to be taken for a child about the right that he's supposed to get. Right of information. He should as well, I insist, as well get clear information about the right of given by the present directive. Why this restriction for the others? Does it mean that this information about the right is not useful for the other children? I doubt it. In the criminal procedure for minors, no attention is being mentioned about this right for of information for the children. CPGN, this is how it's called, says very briefly, gives a link to the criminal procedures saying that they are applicable to minors, except if there are other measures. Article 13.1 of this. The mother, CGPN, always, the child always replaced by the word minor. Is this a symbol? No. The corollary to that, the right to have the recording made when they are interviewed by the police. So the right of the children are guaranteed, with, unfortunately, the possibility to derogate to that when you make the interrogation in another form. That's the point 2 of the text. So the French authorities took advantage of the derogation after the decision of 1945. The recording, because there could be a cancelling of the protocol if there is no recording of the questioning made. Sorry, that's CPGM. No condemnation. Article 4 from 1312. Progress has been made on the accompanying measures, the presence of the parents, and the creation of an appropriate adult, which was not mentioned before. Now, this right is written in our code for justice for minors. And I come back to the presence of the lawyer. Fundamental, as Filkins says, the role of the lawyer, free, independent, well-trained, is more than ever a necessity. And we are lucky enough to have a lawyer mentioned in this directive. Point 25 to 33 are mentioning the presence of the lawyer as soon as the children are informed that they are suspected, before they are even questioned, when the child is it has to be said the lawyer should be as soon as possible present on the side of the children during the questioning, and the respect of confidentiality, correspondence. Article 5 mentions that. Unfortunately, to have the support of all the states, many derogations are mentioned. If it's not proportioned to the circumstances of the case, according to the gravity of the criminal offense, point 6 of the directive, an exception has been made. So this is really questionable. No lawyer. Okay. So it said, well, the President of the law, it's not absolute a necessity. It's a temporarily exceptional, only in the preparatory phase, take into account the highest interest of the child.
But whatever the framework substituting to the presence of the lawyer, it is still a big lack to not enabling the presence of a lawyer. As for France, the lawyer is present at all times, and we have obtained, and it is to be noted that in the CGP, even in the free audition framework, the lawyer of the child will always be present. One last word on something that is fundamental. You know that children lawyer in France, and notably with the group I created with Thierry Bickers at the National Council of the Bars, we advocate the acknowledgement of a necessary specialization in this discipline. And we have obtained that thanks to the CMD during the General Assembly on the 4th of June last year, this specialization was created. An ordinance of the Keeper of the Seals has officialized this specialization, and it's a great step in the defense of the rights of minors and children. There are lots of things to be done to improve the rights for children. Detention, custody, it should not exist for children, even more before the judgment. It is not being put into question by the directive. That last directive is a last resort measure. And Europe should go further, as lawyers in Europe intend to do. Let's dream together. Let's dream about lawyers specialized on the rights of children in all countries of the Union, with secured networks, thanks to lists guaranteed by the bars to defend their young clients who move around in the Schengen space. Let's dream about a European state, a European space refusing the custody of such children and proposing other alternatives to insult, so that they can insult themselves in the society. And let's dream and make that a reality. Thank you very much. Thank you very much, Dominique. I really believe on the use of these networks of lawyers in Europe, and not just for the right of children, but I believe that these judicial networks in Europe show their positive effects, and there's also the network in civil and commercial matters. It's 20 years old now, and this network with the partners from the lawyers' side, they're not always known, but that network has enabled a better knowledge of the law in the European Union, and we can dream that we can become partners of this judicial network and the penal matters under certain conditions, but perhaps sometime in the future the lawyers will be partners for this judicial network in penal matters. The only partner of this network are the judges and with the European Union. So that will be perhaps extended in the future. So Laurent HUET will have the floor, a counselor for penal justice, the permanent representation of France at the European Union. And Laurent, you have the floor. Thank you very much, Mr. President. And as my daughter said to his friends, my father is a judge, but he plays diplomat. So I think we all belong to the same community of partners in work. I'm very happy to be here. I thank Laurent Pettiti to have invited me. It's really For the next 6 months, I will be involved. I will be presiding a group about some of the instruments that Mrs. the President of the Paris Bar has reminded. And the second reason for which I'm very happy is that the second topic that you have invited me on is very interesting and very dear to me. So let me perhaps give a little picture, a little history. It's important to know where you come from, in order to know where you go, and to give you an idea of the landscape of the legal system in Europe in terms of the protection of procedural guarantees, and perhaps to draw some lines, some headlines for the future. What I will say will only be my personal position. If I can use Saint-Just, the procedural guarantees are a little bit like the happiness. According to the Council of Europe, with this fundamental convention for the safeguard of human rights and freedoms, contrary to that, to the Council of Europe, the European Union and the European Community in its original treaty does not mention the procedural guarantees at all. And with the fundamental rights as well. It is not about these topics. The European project was built on an economic integration, and there is no preamble on the protection of rights on the model of national constitution. It is only progressively that the European Court of Justice is seized on these topics with these some important ordinances in COEUR in 1969, in the 70s. Is taking on this topic of fundamental rights and by making them a fundamental principle of basing the European Union, and then through the Treaty of Maastricht and the Treaty of Amsterdam is really engaging with what the judges in Kirchberg has been doing for. This quick history brings us perhaps to these current times now for the enshrining of the procedural guarantees in the right, in the European law. Under the third pillar, you remember this ex-third pillar, you remember the European Union as a justice pillar and internal domestic affairs with this institutional landscape. Then we had the first tools, the first instruments for a judicial cooperation with to cite them, the main instrument, the European arrest warrant, but that development of judicial cooperation instruments is really questioning the two fundamental instruments, the acknowledgement, mutual acknowledgement, and the principle of legitimate trust. And if I remain with this example of the European arrest mandate, if a judicial authority is being entrusted with a person, a defendant, whereas potentially it could be a national person, it's really a rupture from this principle of the fact that outside of an extradition procedure, nationals are not being entrusted to another state. Of course, then the receiving state can expect that the guarantees are at the same level in both countries and protecting the rights of the defense and fundamental rights in more general framework. Which is why, as of 2003, the Commission has proposed, during an enlargement of the European Union, there was this green book. A green book in the European jargon is a reflection, a thinking process, a brainstorming. It's just before a white book. It's really a green book. It's a pre-white book, and that can bring on a legislation in the future. So this green book in 2003, there was after a framework decision. It was before the directives. It was the third pillar of this intergovernmental cooperation in the Treaty of Maastricht. In 2004, there was this framework decision that brought about a minimal basis for procedural guarantees in the European Union. It was a failure. it was a failure. There was many negotiations, 5 councils of ministers of justice, 6 states in the end were reluctant. And as you know, in this third pillar, in order to adopt this position, there was a veto right. It was unanimously required, and so there was no vote on this, and it was a failure. So the Commission came back a few years later in 2009 with a new strategy, with a sequence, a phasing of the legislation, the proposals for legislations for the protection of procedural guarantees, and not making this as a package before, a transversal package. And this roadmap on the procedural guarantees, and it was invited by the European Council in 2009, proposes this roadmap to the Commission, and you can relay this to a favorable context. First of all, the judicial landscape has changed with the Lisbon Treaty. There's a communitarism of the legal activities. This third pillar, justice and domestic affairs, that doesn't exist anymore, and it's more in the common approach. And there are directives as of that time, and this is ordinary legislative process. And this is not unanimously required, it's a qualified majority. So the consensus are easier to find, and the member states don't have a veto right in the individual position. Second contextual elements, a political willingness from the heads of state to impulse a new momentum in this space of justice. It's the European Council in 2009 with this new 5 years plan for justice, 2010-15, the Stockholm Programme, that came after the Tampere and the La Haye processes. And the last item, it's not a positive element, but it's more a consequence, but it's a symptom of this momentum, the creation of a General Directorate for Justice, perfectly autonomous. Justice was before mixed with this justice, domestic internal affairs. Justice becomes, in its own right, a focus of the European Commission, and the Vice President of the Commission is now legitimate in political matters to intervene in this roadmap and this Article 82 in the Treaty of the European Union, and she will use those possibilities. And I was the head of the justice sector in European affairs. I was on the first front row, and there was lots of things. The European Prosecutor's Office, the RGPD. There was lots of things. There were lots of things to do. I was busy at that time. So about this roadmap, Dominique and Mattias have underlined this. There are a number of measures that have given rise to a number of directives. There's even a sort of transverse directive 2016 on the presumption of innocence, 343, that was not in the initial roadmap, that sort of completes the edifice. And there's also this legal aid directive. In fine, all these directives have been transposed and introduced in the internal legal order, and the Commission is now, as a keeper of the treaties, is monitoring very closely the situation on the transposition of these directives, of the letter and the spirit of the directives, but also but their practical, effective implementation, I would say. Now, about a first statement of the situation on this roadmap, on this judicial landscape, I think it's important to see that the construction is complete. We can always perfect things, and in matters of fundamental rights, the sense of history is that it's always to be improved, in particular in democratic states where the rule of law prevails. But I think we are in a moment where member states have to digest, to integrate these instruments, and there has been some impacts, various impacts, depending on the countries, and the Commission is doing some benchmarking, some evaluation reports, implementation reports, to find out whether we should go further. And it's simpler today to find consensus, as I mentioned, because we have this ordinary legislative procedure with a qualified majority. But the singularity of the legislative process in Europe it's still a matter of consensus. You have to agree at the Council. Okay, you don't have the veto rights, but you can have blocking minorities. You can have, and then the Council has to agree with the Parliament, with the European Parliament on a draft. This draft will evolve and might be different from the initial project. So it's still a process. It's on the desks of the Council and the European Parliament, and then you have the trilogues, and you have this parliamentary shuttle. And so with all this process and this consensus, infinite consensus that is necessary, I think, and many observers also think, that the judicial corpus that coming out of this roadmap is quite ambitious and will enable to complete, to really bring a minimal base in terms of fundamental rights. You always have some little lacks, the measure AE that you mentioned, on the particular guarantees for defendants that have a specific vulnerability, and that gave rise to the directive on minors on penal procedures. The E measures was more ambitious. So you might consider that vulnerable adults with disabilities are not submitted to a specific text. So maybe there would be something to say here, to do something here. There was also, and this was discussed in January 2021, globally the legislation in the member states enable to taking into account the vulnerability of an adult, disabled adults. But it is up to the judge to interpret also the implementation of these texts. And constantly the judges question the European Court of Justice. Last month, a tribunal in Villefranche-sur-Saône has requested from the European Court of Justice a question for the right to information in penal procedures. So remains the question of pretrial custody, remand custody. We had these A, B, C, D, E measures through which the Council was asking to the Commission to propose judicial instruments, directives. But the F measure was only inviting the Commission to start a thinking process with the Green Book, as I mentioned before. What comes out of this thinking is that the Commission has submitted this Green Book. Many studies have been done by the Commission. It was outsourced for the most part. But what comes out of it is the requirement that for all member states in the Council, that it is not necessary at this stage to harmonize the criteria for pretrial custody and the condition, the imprisonment conditions. And it was discussed 3 months ago at the Council of Ministers of Justice in Luxembourg on the 7th of October. There was a Slovenian presidency, and it came out that member states have not identified this requirement, this need. The Commission is doing lots of things with this Agency for Fundamental Rights, with a database on this. The European Commission also is trying to map out the financing possibilities in this multi-year program to improve the situation of prisons and detention. And the Commission has also committed on recommendation at the end of 2022, that will be a Czech presidency, aiming at proposing good practices in matters of detention and detention criteria. What is here is that the existing tools at the Council of Europe level, and notably under the view of the Judge of the Strasbourg, and I will leave my colleagues to develop this, enable with the Article 3 and Article 5 of the European Convention for Human Rights to bring up the standards in matters of pretrial custody. And along the same lines, the case law, be it of the European Court of Justice or the European Court for Human Rights, has developed over the last few years an ambitious case law in these matters. I pick up on this, an example that I use, the European arrest warrant. Because if I, with a judicial competence with this interesting European arrest warrant compared to extradition, if I have to remit one of my nationals, in another country, in another, I wish that the procedural guarantees in matters of detention and the conditions of detention respect the fundamental rights. And the Court of Justice of the European Union, there was an ordinance 2016, I believe. I will try to be shorter maybe and finish my intervention. And in March 2021, there was an ordinance of a Strasbourg Citizens Against France disposed that if there is an emission of a European arrest warrant and if the detention conditions do not respect the Article 3, prohibiting the unhuman detention conditions, this arrest warrant may not be executed. Quickly, some trends and evolution that will come up. The idea is that is being developed is to put the refusal motivations directly in the instruments, and it was the second directive of the Directive 2014 that enables to a judicial authority to request investigations in another member state. The Article 11 of this Directive 2014 disposes that if the state, the emitting state for this decision of European investigation does not respect fundamental conditions, for example, if the state that should execute this is not obliged to execute that. And the idea, generally speaking, is to reopen the debate. In this cooperation, judicial cooperation, this refusal doesn't exist. On this particular item, I think it could be a wrong idea, a wrong good idea. As Montesquieu said, you have to have a shaking hand here before signing a text. Adding motives for refusal based on the non-respect of fundamental rights and procedural guarantees by the emitting state of a European arrest mandate. The danger is that if you reopen the decisions here, if you Lisbonize it, as we say, we can go a little bit further because the judicial landscape is different. We have this qualified majority on the process. But the risk is that paradox. It's a regression in the judicial cooperation. In 2002, we have never gone that far in terms of judicial integration as of that time. And it really has a link because it was adoption context, adopted in June 2002, 1 year after the World Trade Center attacks. And the risk is that if you add many motivations for non-executing this and that, the risk is that you will remove the substance of the instrument. The instrument is not perfect, but it is still there, and it is the highlight of the judicial cooperation. Even the Britons have kept this instrument post-Brexit because it's an instrument that is really interesting. Last item on the current trends, we can always go further, but the procedural guarantees for on the penal procedures, it's really we're sliding from procedural guarantees to the benefit of victims. There are some dedicated instruments. There's a Directive 2012-19. There's the Ordinance of European Protection, also dedicated instruments, and a little bit of here and there, little measures. The rights of for victims is very diverse, and as Genevieve Pavlovska has been designated as a representative for this. And the directive that was cited before, this proposal of directors that will be filed, that will be submitted on the 8th of June. There was a violence to women, and I will have the honor to preside this negotiation group within the Council. We know that there will be lots of dispositions for victims of domestic violence and sexist attitudes. And so with a center of expertise for victims of terrorism that could be used as a platform for exchanges at the Commission level. And this very important topic, and I will conclude with this, very important for France. France is very invested in this European network for open victims, this open victim cooperation. And let me advocate an event on the 10th of March in Paris. Will be organized a symposium on the help for victims of major crises, natural catastrophes and such crises. So there will be this event organized in Paris, and you're dearly invited. And it's really a topic about procedural guarantees going towards the victims and also the accompaniment of the victims. It's a new trend in the legislation in terms of public policies. I've been a little long, and I will give you back the floor. Thank you very much. Thank you very much, Laurent, for this very complete landscape, and I would give the floor to the French judge at the Mattias GUYOMAR Judge at the European Court for Human Rights. Mattias. Thank you very much, dear Laurent. I would like to really thank the organizers for this day, to have proposed myself, to propose me to be a distinguished speaker, even though we are in the auspices of the European Union. But the European Court for Human Rights has many common points, and these we are really this gateway enabling these guarantees that are protected in both our judicial corpuses, legislative corpuses, try to converge and complete for the efficient protection of rights. And I'm very happy to bring here the voice. I have 12 minutes, I believe. Laurent told me, he gave me 12 minutes. But I would like to also say, as a judge, I'm very happy to be here with the lawyers, colleague lawyers. We have this wonderful formula of this partnership judicial system. And I've always thought, when I was a judge at the Conseil d'État in France and as a European judge, there's really a partnership between lawyers and judges. Without the lawyers, there wouldn't be any justice. And without you, there wouldn't be any justice. Thank you. Thank you. Good start. It's a good start. Okay. But it's very sincere from my heart. I really measure the effectivity, the efficiency of the protection is on your shoulders. You are the counselors of the defendants. You bring them forward. You help the judges to make it so that the administration of justice is correctly done. So I would like to say that really, and let me come to my point. But I think it's my point. It's my point in a way. It's transition with this convention. The lawyers in these European conventions are actors and actors and subjects. You are actors because you enable the internal legal orders to be irrigated by the convention, but you are also submitted to this convention. That is, you are, as lawyers, you are the tenants of a number of rights that are defended by this convention. So I found five main themes. Since I need to be synthetic, we have lots of case law about lawyers, but the first one is that the lawyer has an essential protection. It is an indirect protection, but it's really a crucial guarantee. The second is about the scope of this protection that is granted in a large spectrum of situations. The third is The right of the lawyer is not unlimited, and the court is trying to bring a framework around it. The fourth is that, as always, at the court, we make it so that the rights are not illusory, but concrete, effective, and it's really effectivity of the right of the lawyer that is really enshrined in our convention. And fifth, the spectrum is large. It's not an absolute right, but I would give a word on restrictions that can be brought to this. This indirect protection, that's my first point, with a crucial guarantee nevertheless. Why indirect? Well, the lawyer can be protected for himself or herself, but most of the situations, the right to a lawyer is one of the conditions to the effective respect of the third party's right that you defend. And so this indirect and very direct at the same time, because you are at the heart of our judicial system. And to paraphrase Hannah Arendt, the lawyer in fact is the necessary condition for having the right to have rights. The right to that's the rights are indeed respected. And in our case law, we have many formulas that recap this crucial mission. As I said, it's a guarantee with an indirect protection, but it's a crucial one. And the lawyer contributes to the implementation, the realization of the aims by articles in fairness trial, but the exercise of the defense rights and the equality of arms. And I really believe that you are the guarantors of the balance. And that's what we make sure. And that's the lawyer is bringing balance where there is some asymmetry, and I've heard many things about the migrants and the minors who are very vulnerable. But the defendant is always in a position of asymmetry, and the lawyer is bringing back the balance in this. Let me move to my second point. I mean, lots of things to say, of course. Why is it essential? Because our case law that develops lots of procedures under material rights is constantly making a link between procedural and material. There's an independence. It's not out of nothing. It's always at the service for a fundamental right. Second is the scope, the extent of this protection that we grant in this case law. Of course, we always think about the trial, the role you have in the trial. It's the Article 6, Alinéa 3 and C that will define the extent of the right for the defendant can defend himself or herself, or to have an assistance for a defender of his choice, and if he doesn't have the necessary resources to have legal aid, well, the interest of justice requires so. There are three rights here in this Article 6, that of having the defender of his choice or her choice, and that's to have legal aid, free legal aid, if needed. But I'm really convinced that there's a continuum in the exercise of your function. The Article 8 is also protecting the relationship of the lawyer and the client in terms of private life. There was Altay against Turkey. We protect the exchanges. The exchanges should be confidential, including in situations that have nothing to do with a trial or an upcoming trial. And this privilege situation that is granted to the relationship between the client and the lawyer, Article 8, protection of intimacy, is extremely important to know. It starts very much before the trial, and when you help people, vulnerable people, it's also this duty of counsel that is at the heart of the intervention of the lawyer. Laurent, there was a Michaud against France, but the ordinance, I had known this at the Conseil d'État because I was a public rapporteur of this case in 2009 on there was this money laundering accusation, and we were talking about that. The court said, because you haven't devoluted this to the Court of Justice, there was not the inadequate mechanism and so the presumption doesn't come in. So I control the solution, and we were very happy at the Conseil d'État, and that the court has said there's nothing to say to what the Conseil d'État said. And the Conseil d'État had said that, of course, the Court of Justice said, but we had this protection under Article 8. The protection of the confidentiality of the professional secrecy, and we are coming to this professional secrecy aspect. It's a very hot topic, as you know. It's really the key, the professional secrecy, the confidentiality, and this has been enshrined in the case law. What are the guarantees that are there for the assumptions in which that confidentiality should be waived? The fact that it will go through an intermediary, the intermediary of an instance of the profession, is also a fundamental guarantee. So it's a continuum, in fact. You are protected. The people that you defend are also protected, Article 6 or Article 3, with this autonomous scope that we acknowledge for penal matters. Thanks also to the interpretation, the extensive interpretation of private life under Article 8. I'll try to be fast, but I'd like to mention my 5 items. Third, this right is not without limits, and even us, we make it so that we respect the framework. 6.3 Article 6.3 disposes that people have the right to defend themselves. It's a sort of a contradictory thing here. There's an obligation by the internal law for representation. People have not the right to represent themselves. But they come to us and says, Article 6.3 enables me to defend myself. So we have a strict control here, but we accept that the interests of the justice prevail. And that phrase always comes in about the role of the lawyer. And it really shows here this partnership, the interest of justice. When the interests of justice require an obligation of representation, then that's the possibility of representing oneself should cede. So there's a limit to the limit, I should say. The second one is that you can always give up on the recourse to a lawyer, but the court is very vigilant here, and it has to be a conscious and enlightened renouncement, and not under threat or on a non-deliberate way. It has to be deliberate, and there's always a faculty of coming back on this decision. So it's always possible. You think that you don't need a lawyer, that you can represent yourself, but you can always change your mind. And that is a faculty that is enshrined. Fourth, these guarantees should enable that the mission of the lawyer be effective, and that's in concreto control that we exert in all domains. If I may, it's really the modus operandi of the courts. The fact that we are seized by individual recourse implies, of course, a very strict control. These concrete guarantees are legal aid. The right to free legal aid is really enshrined in the text. There are conditions, of course. It's not a full right. The financial situation of the defendant and the interest of justice here should command. But we have in the legal aid is in most cases, I say it's almost, we don't like to do presumption processes, but the right to legal aid is You can see Ben-Am against the United Kingdom, for example. So this legal aid should be concrete and effective. It means that there's a lawyer shall be designated, and the lawyer may be mitigating this possibility to choose. You have the choice of a lawyer. It's not an absolute choice, and there might be here also a fine control by the court on the fact that you waive the decision of the person, including in this designation procedures. You have to take into account the willingness of the defendant. And there was one case that there was a relevant and sufficient motivations have to be provided to go beyond this. But also, I think it's very important to say that we require, in a way, that the state responsibility might be engaged if there's a lack of designated lawyers. So we have this mechanism that really, if somebody you haven't chosen but doesn't do the right job, from the convention, it's really the responsibility of the state, because the state has designated the lawyer and should be responsible for that. Confidential communication of the lawyer, it's one other condition for this effective right to the help of a lawyer. We can see very pragmatically to this respect of private exchanges. And of course, we have concrete examples that give us lots of food for thoughts and looking at some specific situation. And eavesdropping, for example, of it doesn't work in our case law. There's Zaccaria against Italy, for example. But an excessive limitation and systematic limitation of number of visits that a lawyer should be able to pay to the client, it doesn't work. That's Okalam against Turkey, for example. There's a number of things here. Even a judge, a investigation judge, the contact and the judge and the detainee, that doesn't go. So in fact, in reality, we can see many ways to try to have an indirect control on this relationship. I think this sanctuarization should be really enshrined in the processes here between a lawyer and the relationship between a lawyer and the client. And it's really exceptional if the lawyer has illicit behaviors, but it's really extremely rare. Well, we all have our pathologies. Any profession has. I wasn't expecting to have a round of applause on this. Judges also have their own problems. And I will finish with the fifth item about the scope and the extent of the right. It's not absolute. It's not absolute, but it's very wide. And I think it's essential to say that we have extended it to all phases of the procedures, the right to a lawyer. The right to a lawyer in custody comes from the European Court of Human Rights. There's the trilogy, Ibrahim Buz, and that really enshrines this general right to the help of a lawyer during the whole procedure. And the fact that we have an autonomous conception, our own conception of penal matters, reinforces that protection. There's the idea here that on the upstream part of the process, investigation, perquisitions, and you're on the field very often. You know that, you can measure that. This upstream part of the process is really critical, and there can be some decisive things here playing out. And if you deprive the people at this stage of their rights, it could be an irremediable loss. And I will like to finish talking about the restrictions that can be brought to the access of lawyers. We have this as a principle, but we have limitations. Buzz against Belgium, for example, the Grandchamp ordinance has really, there was this test in 2 steps. When you don't the contracting state defending to the court has not allowed to the person to benefit from the help of a lawyer in upstream, I would say upstream phases, custody most of the time. We have a series of affairs with 3 auditions in France that should be coming out in 2022 with the presence of a lawyer. So restrictions do not entail a condemnation, an infraction, a violation. There's a text in 2 steps. Are there imperious reasons justifying this delaying? It's not a refusal, it's a delay of the process. And second, does it mean I should finish? Is that a warning? Some ominous. I'm almost finished. And if yes, we move to the second step. If no, we still move to the second step. It's the equity of the procedure, but with a stricter supervision of the procedure. So, the global fairness of the procedure is very criticized in the case law of the court. And let me say one word about this. It's not new. And you all know the case law of the court. But you know, the publicity of the audience, we've always done that. We've always done that. The default of publicity in the first instance could be purged in the appeal, because you judge the whole case. The same thing for the presence of the person in the audience. Wasn't there in the first instance, but in the appeal, and if the person is there, then you have a full trial. But in the end, you have to understand the position of the European Court. It's not an internal judge. It's not a control of the respect in regards the internal law, the internal procedure. It's not a judge of the cassation checking whether the procedural guarantees have been respected. It's a judge who has to respect that the rights protected by the Convention or implied by the respect of these rights have been globally guaranteed. But it's a shared responsibility. The lawyer does what he has to do. The court is a subsidiarity principle. And if the court is being seized, we have our own supervision. So there's the state and the court. We do things in English. We have a global picture of it. It's a large picture. You look if at the end, all things considered, the fundamental rights have been globally respected. By doing this, we take into account a number of elements. It's sort of balancing of things. The vulnerability of the person is taken into account. The seriousness of the violation, was it just half an hour or the full interrogation, 4 hours long of the person? We always take into account the declaration, the statements of the person. Are those the only ones that have been used for the court? Was it possible to contest the origin of the evidence or their validity? So we have a fine control here. And at the end, yes, there might be a case where the refusal to grant immediate access as of the first moment to the lawyer might be, yes, in the end, has not affected the global fairness of the procedure. Well, it's the way we work, and we have this test in 2 steps. We really, the whole the spectrum of instrument we mobilize for this, we really try to never let go a situation in which, yes, indeed, the default of the presence of the lawyer would have deprived the person, the defendant, this right to balance in a fair trial. And with all this, I would like to conclude the case of controlling refers to 2 things: the right to not self-incriminate, and in fact, you can see clearly, and it's in this regards, and those rights are essential, and our case law reminds us all of this. It's not a French tradition, you know, but these rights are there, are enshrined really now with this convergence with the law of the European Union. It's really at the heart of the requirements today. that the interests of the justice are there to be respected and are there for that. And I will finish here. This interest of the justice, in the interest of justice, is that concretely, in a concrete, day-to-day way, trivial little things, little niblets of things can be absolutely indispensable or fundamental for the defendants and the people brought before the courts. That the lawyer can be there, can operate with the fullness of the instruments that are accessible, because in a way, and that's what I said, there is no justice if there are no lawyers, and that's we always try to do when cases are brought before the court. Thank you very much. Thank you very much for this remarkable plea. You've seen the intensity of the applause is even higher at the end than at the start of your intervention. I will leave the floor to the second roundtable now, thanking the speakers.